At the start of World War II, Winston Churchill said, "We shall fight on the beaches, we shall fight in the air, we shall fight on the hills, and we will never surrender." Well, I don't think the Second Amendment fight is exactly the same as Winston Churchill urging on the Western countries to fight the Nazis in World War II. It is very similar in the sense that fighting for freedom requires us to fight brick by brick, inch by inch, man by man. And I'm happy to report out of Hawaii a major victory for an individual, Blake Day, thanks to the excellent lawyering by several lawyers, including Alan Beck, is something I want to talk about, and the importance of each individual American that prevails on the Second Amendment is a victory for all of us, because we are all in this together. Because as Benjamin Franklin said after signing the Declaration of Independence, if we do not hang together, we shall certainly hang separately. Let's talk about all this and this major Second Amendment win in Hawaii for Blake Day when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of many Second Amendment books, including another one being announced very soon, including Disarm: What the Ukraine War Teaches Americans About the Right to Bear Arms. Now, happy news out of the county of Hawaii. Blake Day versus the county of Hawaii, a big win for the Second Amendment, a huge day for the plaintiff, Blake Day. Now, specifically, Mr. Day wanted to get a concealed carry permit, and of course after Bruin it's a shall issue system, but of course Hawaii is insanely anti-gun, perhaps because of the spirit of aloha. The spirit of aloha, like literally you can't make this stuff up. Nevertheless, the old kingdom of Hawaii has been overthrown, and the Second Amendment should reign supreme, but we're still working on that, and the excellent work of people like the plaintiff Blake Day and the attorney Alan Beck is helping to do this exact thing. So specifically, Blake Day wanted to get a concealed carry permit. He applied but was turned down on the grounds that he had allegedly been involved in some sort of altercation, a nonviolent altercation where he asserted his self-defense rights. Mr. Day, according to his complaint and his motion for a preliminary injunction, was in the foreclosure business and sometimes had to go into very dicey situations where he was foreclosing on a property, and sometimes the owner of the property is not particularly happy to have his or her property foreclosed upon by a creditor such as a bank or mortgage company. So Mr. Day wanted to get a concealed carry permit. He applied but was turned down. And he in turn sued, and they filed a motion for a preliminary injunction. Now, what's really interesting here, before we get into how Mr. Day won this big win for himself and now has a carry permit, we'll talk about that in just one second. What's very interesting is the shocking, terrible record that the county of Hawaii has on guns. Let me just read these critical facts. Unbelievable. You can't even make this stuff up. That was filed in the litigation papers in behalf of Blake Day against the county of Hawaii. Up until recently, the county of Hawaii had never issued a concealed carry permit. The Supreme Court's decision in Nyserpa versus Bruin compelled the county of Hawaii to issue permits to carry concealed handguns. This it has done reluctantly. It has put in place a series of policies which unconstitutionally restrict the rights of county residents. At issue here is the Hawaii Police Department license to carry, concealed and unconcealed, application processing procedural manual, the manual which precludes an individual from obtaining a license when the chief of police uses his discretion to determine they lack good moral character and or appear unsuitable. In plaintiff Day's case, he is being denied his Second Amendment rights solely because he used non-lethal self-defense. So that's right. There was a story discussed about how he was confronted by someone in the context of a foreclosure, and there was an exchange of unpleasantries, and this was allegedly a basis for the county to deny Mr. Day his Second Amendment rights, the ability to carry a gun. But I'm happy to report that upon the filing of this motion for a preliminary injunction and this lawsuit by the attorney Alan Beck and Mr. Day, the county of Hawaii has rolled over and has conceded that Mr. Day does in fact have Second Amendment rights and should get his license. And that is exactly what happened. I'm happy to report that Mr. Day has now received his concealed carry license pursuant to a stipulation in this case. Now, if you look at the powerful papers in support of the preliminary injunction, once it was filed, the County of Hawaii rolled over and says, we want to settle this case. And they settled it by issuing the license to Mr. Day, specifically according to the stipulation that settled the case and dismissed the lawsuit with prejudice because it was no longer needed. It specifically says that Plaintiff Blake Day was issued a license to carry by the defendant County of Hawaii on January 2nd, 2023, which license is valid until January 2nd, 2025, and defendant shall not declare that plaintiff's license is void unless he turns out that he is not allowed to possess a firearm under 18 U.S.C. 922G, essentially. So the good news is, again, major win here, settlement by virtue of, really, as I see it, a metaphor of punching a bully in the nose. You know, the old saying is a bully is only as tough as when somebody confronts him and punches him in the nose. It seems like the County of Hawaii was trying to bully Blake Day into giving up and waiving his Second Amendment rights. But Mr. Day hired Alan Beck, an attorney, and punched the bully of the County of Hawaii in the nose. And the County of Hawaii, once they got punched in the nose with this lawsuit and a motion for preliminary injunction, guess what? They rolled over. Now, what's quite interesting about the argument made by Mr. Day's attorneys, and Mr. Day in this case, was they talked quite a bit, and we've talked about this before, the importance of having no discretion. When you have a shall issue permitting regime, the one thing you simply cannot have is discretion on the part of a licensing official. If you look specifically at footnote number 9 in NYSERPA versus Bruin, it talks all about that the exercise of judgment and the formation of an opinion by a government official is a no-go. The only thing they're allowed to do is to check boxes objectively. Have you ever been convicted of a felony? Yes or no. Have you ever been in prison? Yes or no. You know, these absolutely objective questions. Do you use drugs right now? Yes or no. Are those drugs illegal? Yes or no. That kind of stuff. This is objective. There's no debate about it. There's no I feel, I sense, it's my opinion. None of that, because that constitutes the exercise of discretion. And the one thing that footnote 9 of Bruin says is there cannot be any discretion. The Supreme Court wrote the following in footnote 9, the relevant part, that says that the shall issue permitting regimes had objective standards. Specifically, the court wrote in footnote 9 that these shall issue permitting regimes likewise appeared to contain only narrow, objective, and definite standards guiding licensing officials rather than requiring the appraisal of acts, the exercise of judgment, and the formation of an opinion. You see the key difference. There's objective facts, are you a felon? Yes or no. Do you use drugs? Yes or no. Versus discretionary opinions like, do I think you need the gun? Do I think you're a good person? Do I think you're moral? No. The use of opinions is a no-go because it becomes subjective. And in this briefing in the Blake Day versus County of Hawaii case, there's a series of examples, including some of the cases we've talked about on this channel. For example, out of New York, where given discretion to licensing officials is a no-go. If you do that, it no longer becomes a constitutional right, because government, you do not have to go mother may I to the government to exercise your constitutional rights. You don't have to go mother may I. Do I have permission to engage in mass on Easter at a Catholic church? You don't have to go mother may I post something on X. You don't have to go mother may I protest, set aside parade permits and things like that, which is a sort of a different category of things. But even there, parade permits and protest permits, again, the standards for who gets those permits and licenses, that has to be objective as well. But if you just want to exercise your First Amendment rights, or you want to pray, again, you don't have to go mother may I do so to the government in any respect. And again, these shall issue permitting regimes, because they're objective, means you don't go mother may I. You're simply applying with objective criteria, and if you meet it, you get the license. And again, we could talk about some of the other issues associated with shall issue permitting regimes in other videos, but for today, I just want to celebrate the fact that we have an individual American Blake Day has won this case. Now, this is important because this is a precedent I'm bringing to your attention. Because again, even though there was no court ruling or opinion, it is a victory, and it's something that I want you to be aware of, especially if you live in Hawaii or the Ninth Circuit, to be aware of a situation where, here's an example where once the government was sued, they rolled over and gave that individual the remedy that he sought. And that's very important for you to understand. Not that I want you all to go out and sue for your rights per se, because it's unfortunate that some of you have to do that because we live in the kind of world, especially if you live in some of these terrible blue states. But again, always be aware that sometimes that is an option. And again, whether or not you can collect attorney's fees under under 42 U.S.C. 1988, that's a whole topic of a different video. But it is something to keep in mind that if you prevail in these cases or get the relief that you sought, you can often get your attorney's fees back and paid for under, again, a federal statute, civil rights law, 42 U.S.C. section 1988. But again, we can talk about that in a separate video if there's enough interest. All right, well, congratulations to Plaintiff Blake Day. I'm glad you got your concealed carry permit, and congratulations to Alan Beck, the attorney out there in Hawaii, who we always like to follow his work. He's all over the news and his good fights out there in the West Coast, or the left coast as I see it. And don't forget to follow me on X at @4boxdiner. Make sure you subscribe to this channel. We're trying to get to 150,000 subscribers as fast as we can. It's taken a long time, but we're working hard to get there, so help us get there. And we will see you again soon here at the 4 Boxes Diner.